Good afternoon, everybody. First, my excuse for the 10 minutes delay, but we still had to do a core business in the Senate. That's voting. That was important. We had to do so, but still my excuse for the delay. Okay, I would like to welcome the experts who have joined us today through the video conference and the members of the committee who are present here in the plenary hall and through video conference. My name is Marjolein Faber. I am the chair of the Standing Committee for Immigration and Asylum, Justice and Home Affairs Council of the Dutch Senate. This meeting we will talk about the European Pact on Migration and Asylum, which the European Commission has published in September 2020 on March the 2nd. On March the 2nd we have held the first expert meeting on this subject. We invited the Dutch NGOs and scholars to talk about this subject. Today, experts from the international field will share their views on the proposed European migration and asylum policy. The meeting is organized as follows. The speakers will have a maximum of 10 minutes to explain their points of views. After each speaker, the members of the committee will be given the opportunity to ask questions. The first speaker today will be Ms. Vonkeman. She is the head of the Office of the Unhcr of the Netherlands. She is joined with Mr. Woolard, who will be available for answering questions afterwards. Ms. Vonkeman has indicated she will have to leave this expert meeting early because of other obligations. I give the floor to Ms. Vonkeman. Mrs. Vonkeman, please, Ms. Vonkeman.
Thank you very much, Ms. Faber. Good afternoon, everyone. First of all, I'd like to thank the Committee for Immigration and the Senate for this invitation to Unhcr to give its expert opinion on the Commission's proposal for the EU Migration Pact. As shepherd of the 1951 Convention, we have a keen interest in and focus in the negotiations. Forced displacement and mixed movements are global phenomena. As of 2019, almost 80 million people were forced to flee their country, and their numbers are rising. Globally, 1 person out of every 100 is displaced internally or seeking asylum, and that proportion has risen significantly over the past 5 years. Recent events, such as the fires in Moria, Greece, have highlighted the urgency for the EU to find a truly common, well-managed and predictable approach to address mixed movements of refugees and migrants effectively, in accordance with international law. Access to territory has been increasingly called into question by the repeated nature of reported pushbacks at EU external land and sea borders, and Unhcr continues to call for investigations and a halt to this practice. Deterrence measures such as pushbacks and building fences result, we believe, in part from the dissatisfaction within efficient asylum systems, the lack of solidarity between EU member states and onward movement, and indeed, it's a reality that applications are 4 times higher than actual arrivals in the EU. In my presentation, I will address the questions that were asked by the committee, not individually, but in an intuitive manner, focusing really on the crunch issues that have arisen in the Council. And there I wanted to mention access to territory and border procedures, and also, of course, the asylum and migration regulation. So let me start with the screening regulation. We welcome, first of all, the screening of all irregular arrivals is something that we've been calling for as Unhcr for a long time. We believe it could help to quickly identify persons in need of international protection and those who are not, speeding up processes and reducing limbo situations. We also welcome the proposed independent national monitoring mechanism and would like to call on the Netherlands to actively support its rollout. But we have one concern, and that is that the mechanism needs to be really effective and independent, and in particular because the mechanism would be set up under national law, and we therefore urge that the Unhcr, NGOs, but also lawyers have unhindered access to the border reception and processing facilities to monitor procedures there. We are concerned about the fiction of non-entry in this regulation. It has triggered proposals, as you know, about externalizing protection into third countries. An example is the recent Danish law proposal. Unhcr does not support the externalization of asylum obligations. We're also concerned that the reception standards during the screening will be regulated by national law. This could result in detention practices and substandard reception conditions that may violate international and EU law. And we would therefore like to recall that detention of asylum seekers should not be used systematically for all arrivals, but rather remain the exception. And that we encourage that alternatives are explored first. Welcome in the screening regulation the attention for persons with vulnerabilities and specific needs. But we regret the absence of a proposal in the proposal of independent legal assistance in information provision, and also that access by NGOs or international organizations or lawyers to provide independent information is lacking. And we would therefore like to encourage the Netherlands to grant access to border reception and processing facilities to those organizations. Another concern we have in the screening regulation is that there's no judicial review of the screening, and it's merely considered as an information gathering stage. In our view, what would be important is that applicants and their representatives should have access to the debriefing form created at the end of the screening to enable them to rebut any presumptions that may arise from the information collected. This is very important because it, of course, has influence on which procedure they are later on channeled into, for example, a border procedure or not. Then, as regards the amended asylum procedures regulation, we generally support the introduction of border procedures, and we also support the proposal's aim to make a link between all stages of the procedure, from arrival to processing of asylum requests and a final decision. This to limit onward movement, unnecessary appeals or subsequent applications where there are no new elements and where they are solely lodged to frustrate or delay return and made when return is imminent. We even support that in such cases, expensive effort should not be automatic. However, this joint procedure should, in our view, be applied with respect for key procedural safeguards, including an effective remedy and respect for the principle of non-refoulement. In general, welcome the use of accelerated procedures at borders to quickly identify those whose claim is manifestly unfounded or who present a security threat. But procedural safeguards must be adhered to at all times. We would also like to mention the possible use of accelerated procedures for manifestly well-founded cases, as they could speed up case processing and contribute to decongesting reception facilities at border points or near border points. We further welcome the proposal of in-merit decisions at the border for complex and likely well-founded cases, which should be decided at the border, but we're concerned that admissibility procedures based on the safe third country concept remain, because they could lead to responsibility shifting towards states with less capacity and poorer quality procedures, with an eroding effect on the international protection system as a result. The triaging proposed in the border procedure should be based, in our view, on a proper caseload monitoring and analysis, considering country of origin information, but also risk profiles. Regarding the 3 case profiles proposed, we believe that the 20% recognition rate to channel people into a border procedure could be a starting point, but it will require a closer look, notably as regards identification of individuals with potential risk profiles, such as LGBT, for example, from Northern African countries, but also countries like Trinidad, Tobago, and Russia, for example. We welcome the proposed exemption from the border procedure of unaccompanied children in certain cases with special procedural needs. We are concerned that the proposed border procedure allows for the use of movement restriction and detention during the pre-screening for the 5 days and acceptably 10 days, if there are larger numbers, and during the asylum border procedure itself up to 12 weeks, because it leaves a considerable discretion to individual states as regards the implementation modality. And again, as I said before, we as Unhcr strongly encourage member states to focus on alternatives to detention. Coupled with other measures, we believe, for example, granting a residence permit as also proposed by the Commission after 3 years instead of 5 years, in combination, for example, with treating final cases of move onwards as subsequent applications with no suspensive effect, could in our view also stem flows and onward movements. So using a carrot and stick approach instead of detention. Then moving on to the Asylum and Migration Management Regulation, We encourage the Netherlands to support the proposal, which aims to address some of the weaknesses in the Dublin III system, as you well know, and also has in it endeavours to reduce almost movements and seeks to introduce a solidarity mechanism. We really believe it's essential that progress is achieved on this instrument because solidarity is a break-or-make element for the practical solution at the EU external borders. We welcome the inclusion of search and rescue, disembarkation in the proposed solidarity mechanism, and also the clear indication in the recommendation on search and rescue, which is separate, to not criminalise NGOs for saving lives at sea. And we also support the establishment of predictable post-disembarkation arrangements on the basis of advanced preparedness and mandatory solidarity measures in order to avoid ad hoc approaches as we're seeing nowadays. On solidarity and fair sharing of responsibility, we support that persons with a low chance to be granted international protection will not be eligible for relocation in certain cases. This is important for the integrity of the system. And we encourage, as I said before, the Netherlands to support the proposal that beneficiaries of international protection can gain long-term residence after 3 years as opposed to 5. In our view, this can curb irregular onward movement and work as an incentive to initially stay in the member state responsible. Welcome the priority of family unity and the best interest of the child in the hierarchy of criteria when determining the member state responsible for an asylum seeker, and we also welcome the expansion of the definition of family and meaningful family link to other member states. Another member state when, for example, determining the member state responsible or in the context of relocation. Then very briefly on the crisis force majeure regulation, we welcome the greater focus, as I said before, on preparedness and prompt reaction in times of crisis, with the aim of moving from an ad hoc response, as we've seen before, to a comprehensive and predictable response. And we also welcome the fact that member states can grant a form of protection in situations of crisis fairly quickly, but there also possibilities for family reunification should be looked into and considered, because there's a risk that that may not come with that status that is granted. We are having some concerns about the broad definition of crisis and force majeure, because it leaves a wide margin of discretion to member states and may risk excessive recourse to crisis derogations and a consequent reduction of protection standards. And on the derogations themselves, we note, for example, that the suspension of asylum applications is not foreseen in international refugee law. And we note that registration is vital to ensure that persons have access to essential services and are protected against refoulement and should therefore not be suspended. We're also very concerned with the use of detention, the very wide use of detention under this regulation, both in terms of the duration, up to 1 year, in situations of crisis or force majeure, and also because of the number of people that may be concerned. Because in crisis situations and force majeure, of course, there may be more pressure at the border, leading to overcrowding, substandard living conditions, Moria-type situations. And again, we believe that alternatives to detention should be explored first before detaining someone for asylum. Then finally, on the recommendation on the settlement of humanitarian admissions, of course, this is not a legally binding instrument, but we like to mention it nevertheless. We welcome the very strong messages asking member states to commit to expanding the settlement programs and other pathways, which is really a call to show solidarity with third countries, hosting large numbers of refugees, including an increased number of settlement countries. And we also acknowledge the challenges faced by all the settlement countries due to the pandemic that affected the EU 2020 pledges exercise and was converted then into a 2-year program. Less admissions will, of course, impact refugees directly, and the global resettlement needs, as you know, are very high, 1.44 million. And UNHCR has asked EU member states to admit 30,000 refugees in 2020 and 35,000 in 2021.
Ms. Vonkeman, I'm sorry,
yes?
but can you complete your speech, please? Because your
yes.
10 minutes is
it's almost,
is yes.
I'm almost at the end, no worries. Yes, thank you. So we'd like to call for EU member states to urgently scale up, also in line with positive developments in the EUS, of course, resettlement and also we call upon the Netherlands to do everything possible to meet the targets in 2020 and to support the swift adoption of the Union Resettlement Framework, which will help consolidate predictable and sustainable resettlement programs. I would like to leave it at that. Thank you very much. If there are any questions, I'm happy to reply to them, and I also have my colleague Nicola with me, who can also answer questions about the Dutch context specifically. Thank you.
Thank you, Ms. Vonkeman. I'm sorry to tell you, but it was a bit hard to follow your speech because of the connection was not so good. But we'll try to make some questions by the members. So, does the members of the committee have a question for Ms. Vonkeman? Ms. Karimi?
Yeah. I mean, thank you very much for your introduction. It was really very difficult to follow. So what I could understand was that you welcomed a lot of actually many parts of the pact. So I was curious to know whether you can also summarize your concerns a little bit clearly. So, and I don't know whether something can be done that we can understand you better. I don't know where the problem is, but okay.
Okay, let me try. How is the sound now?
This sounds better. Maybe, yeah.
Okay. Well, I think our concerns are specifically over this non-entry fiction in the screening regulation. I think that's the first one, where, of course, then it would be normally one could argue maybe that the international law doesn't apply or EU law doesn't apply, therefore we call it this non-entry fiction. This is something we find problematic. And then also another problem that we have is with detention, that I also noted that was in the screening regulation. You have 5 or 10 days, but then already in the amended asylum procedure regulation, it goes to 3 months, and then coupled with what could be widely interpreted as a situation of crisis or pressure, it could go up to a year. So people could be for a long time in detention. What we argue is that one should first look at alternatives to detention and not systematically detain people who seek asylum. So those, I think, are very strong concerns that we have. Another concern that we have is also about the possibility in the border procedure to apply admissibility procedures. We have to think, for example, one can think about the Greece-Turkey agreements, a statement rather, but also where similar procedures were applied. In practice, we've seen it doesn't work all too well. They're very comprehensive, they're judicial review, they're very cumbersome and long, and also there's this shift, there's a possible shift of responsibility to states outside the EU, many of which have less well-equipped asylum systems. So therefore we fear that there may be an erosion of the protection regime if this were to be applied systematically. So this is a concern that we have certainly about this possibility to also apply admissibility procedures within the border procedure. How am I doing so far? Is this a bit clearer?
I think it's a bit clearer. Ms. Vos, you'd like to ask a question?
Well, I'd like to continue on this, but because it was not very clear to me. I heard you saying having concerns about the length of the detention. Of course, this is also has been our concern for ages. But do you have any suggestions, or perhaps Mr. Woolard, on how to prevent the duration of detention? I mean, is it a matter of more personnel? Is it a matter of different regulations? This is something difficult for me to understand because we want to solve things and we see the problems, but I think the key is, are there any alternatives?
No, I think that's a very good question. Of course, this is, I guess, a concern of everyone. Indeed, I mean, we already see the pressure now on countries such as Greece and Italy. One thing would definitely be to beef up staffing. That will require an enormous effort because you have to quickly triage cases. You have to quickly process cases. That requires an enormous investment. You have to have trained officers, etc. Smooth procedures. This will require an immense effort from agencies such as EASO, national authorities, etc. etc. So this is a huge operation, and will be even more complex in situations of crisis when there's a lot of pressure. Now, what I said also during my expose was that there are different ways in keeping people at the borders. As UNHCR, we're not only concerned about the length of detention, we're concerned about detention per se of people, systematically detaining people. We're always encouraging, this is in line with international law, not to detain people who seek asylum systematically. You have to have an individual review of the necessity to detain, the proportionality, duration, etc. And it has to be a legitimate aim to confine people. It's really an ultimate remedium as far as we're concerned. And this is in line also with international standards and international law. So we were saying that you could, for example, have kind of a carrot and stick approach. For example, you could say to people who arrive, okay, after 3 years you'll have residence. You have residence permit in the EU, and this will actually allow people to move and look for work or settle elsewhere. This may be an incentive for people to stay on, because they know that ultimately if they want to move on, that this is a possibility. And at the same time, we were also saying, instead, for example, of detaining people, you could also look at sort of measures to discourage people to move on. For example, to say, if you move on, you already have been finally rejected, with an appeal and all remedies basically have been exhausted, if you still move on, then your application, for example, could be treated as a subsequent application without suspensive effect, meaning actually you can't stay then on the territory pending the decision. So that's another possibility. If people are informed about these options and penalties, so to speak, if they move on, despite all the procedures they have to actually apply and abide by, for example, in a border procedure, then these kind of measures could also be looked into. And then also, of course, as I said, detention, you can also have reporting requirements. There are all kinds of alternatives to detention that exist that help to keep people close to where their claims are being adjudicated. And I know the challenges in border procedures, that they are there. We know that. But still, we believe that these should be looked into first, alternatives. And then gradually, when one sees that there's a risk of absconding, one can go to resort to detention.
Thank you, Ms. Vonkman. I mentioned that Ms. Stine, Senator Stine, has another question for you. Please, Ms. Stine, take the floor.
Yes, thank you very much. Indeed, the line is not very good. I have 2 questions. One is I'm the rapporteur for the Parliamentary Assembly of the Council of Europe, the Migration Committee on Gender and Gender Mainstreaming of Migration Policies. So if UNHCR has made any publications on this, also in regards to with reference to the EU Migration Pact, that would be very welcome. You can, of course, mail it to me. And the other question I have is, my own party, but probably in other countries as well, has mentioned in our election program that we are willing to invite people to the Netherlands. So what is the resettlement program, the status of the resettlement program of the UNHCR at this moment, and how does this relate to the EU Asylum and Migration Pact?
Yes, thank you for that question, Mrs. Stine. I'll answer part of that question, and I'll leave the second part, the national component, to my colleague Luc Korlaar. First of all, as I tried to explain, and apologies again for the bad line, resettlement is something as UNHCR that we really encourage. 85% of people who are forcibly displaced are at this moment hosted in countries in low and middle income countries, so outside the EU. And therefore, we believe it's very important to keep support of those countries, to keep people there, to also show solidarity and do our part. And so we encourage, political parties and the government as well to increase the actual resettlement quota. There's an annual quota, as you know, of 500 a year. During the last government, it was enhanced to 750, but then again reduced in the context of the children's pardon, and then again reduced over the Moria agreement. And so what as UNHCR we really see is that resettlement should really be maintained and increased, because people who need resettlement are really in trouble in the country where they are, in the country of asylum. They're not safe there. We're talking political activists, we're talking people who actually fight for gender equality, who have difficulties, for example, in a refugee camp very close to home, where still the same community is there, where this basically persecutes them. So we really believe that those people, those 1.44 million people that are in need of resettlement worldwide, should be resettled in show of solidarity with those countries that are hosting the majority of all the refugees worldwide. And yes, another thing, as I already implicitly said, we also believe protection should remain the protection-centered tool and not be conditional on agreements with third countries, or, for example, be in exchange for reducing relocation quota or vice versa. So it should really look at who is in need of international protection, who is not safe in the country of asylum, close to home. And that's something we'd like political parties to focus on. We really believe it's also, in the long run, potentially sort of a alternative actually for engaging with smugglers and coming in an irregular manner to Europe. And perhaps I hope this was a bit clear, then I can hand over to my colleague Woolard, who can tell you a bit more about the state of play, about the Dutch situation in regard to resettlement and the Dutch resettlement program.
Yeah, thank you, Andrea, and thank you, Mrs. Sine, for the question. I believe that your question was, what is the current state of the UNHCR resettlement program? Just to let you know that in recent years, of course, the numbers have declined significantly because of the United States reduction in the resettlement quota. Hopefully, given the intentions of the US with the new presidency, this number is going to increase. Of course, this had significant impact on our capacity to process cases. Luckily, we have been able to always process those cases that have been requested to us, even though, because we can inflate and deflate our capacity, and we rely on certain deployment schemes. So even if there's an increase from the Dutch resettlement program, there would be absolutely no problem in meeting those increased demands if they are being realized after the new coalition. So, and of course we know that the Dutch resettlement program has a quota of 2,000 in 4 years. Which is divided by 500 per year, and it's and currently they also take 1,000 under the migration deal with the EU, between EU and Turkey. It's that we refer to as the migration resettlement component. So that's 1,500 per year. That of course have not made these numbers in 2020 because of the pandemic. There has been intentions that the number that they have not been able to resettle will be made up in 2021, but also now we are already facing delays because of the mitigating measures of the COVID-19 pandemic. So we hope that at least the quota, the 2,000 4-year quota, is a carryover quota, so that can always be carried over to following years. We also hope that this will be the case for the 1,000 quota from Turkey to resettle 1,000 Syrians. It's not been to the best of my knowledge, this has not been explicitly mentioned yet, that they will resettle all the numbers from previous years from this migration quota, but hopefully this will be the case.
Mr. Woolard, I'm sorry.
Because it's quite a significant number, yes.
Mr. Woolard, can you complete your answer, please, because we are running out of time.
I'm actually finished, so... Yeah.
You complete? Okay, thank you so much. Thank you. I'd like to thank Ms. Vonkerman and Mr. Woolard for their information and their time and their taking part in this video conference. Thank you. Then the next speaker is Ms. Woolard, Secretary General, European Council of Refugees and Exiles. Please, Ms. Woolard, take the floor.
Thank you very much. Thank you for the invitation. So we've been asked to comment on 3 questions. 1, our assessment of the Pact. 2, the role of the Netherlands. And 3, what can be preserved from the current setup. So first of all, our assessment of the Pact. As ECRE, we share many of the points mentioned in your first session, in particular by Femke de Vries from our member organisation, Vluchtelingenwerk, and from Jorrit Reekma, the expert at the University of Leiden. So I won't go into detail, I'll just give the headlines here and refer back to your previous discussions. As a positive comment, I think one element of the Pact and the presentation of the Pact that we see as positive is the narrative put forward, particularly by Commissioner Johansson. There's a strong attempt from the European Commission to normalise this policy issue of asylum and migration. And that's something necessary to move to a more effective and pragmatic approach and away from crisis policy making. That said, many elements of the Pact pull in another direction. Firstly, it is still based on a model of containment at borders, with the screening process and the increased use of border procedures. This will create humanitarian crises, with more people in detention, even if it's not called that, at centres at the border. People will be in substandard conditions, leading to physical and psychological suffering and undermining their later chances of integration. And this derives from the very model itself. Secondly, more people will be subject to substandard asylum procedures, which in our view, border procedures are. They're second-rate procedures, and we refer to the detailed analysis published by the European Parliament last year, to which ECRE contributed, which was also referred to you in your first session. The model will also increase the burden on countries at the borders and the inefficiencies in these countries. They will have to run detention centres and procedures as well as the regular procedure. And I think this relates to one of the questions already posed by one of the members. What are the alternatives? Well, investing in the regular procedure, particularly in countries where things are not working effectively. All of that said, the Netherlands should perhaps consider this focus on the borders as a success, because this is an idea that the Netherlands has been lobbying for in recent years in Brussels, based on the Schiphol Airport border procedure model. We have doubts about the effectiveness of replicating or trying to replicate such a model across the borders of the EU. And I think it reflects the priority of some countries, which is stopping so-called secondary movement or onward movement within the EU, regardless of the cost. Here I would refer to the study on secondary movement commissioned by the Dutch government itself from the Advice Commissie voor Vreemdelingenzaken, which shows the complexity of the phenomenon of secondary movement and the need for a more sophisticated approach rather than one based just on detaining people at borders. The basis of the Pact is a sort of deal where there is this increased border containment in exchange for increased solidarity to the countries at the external borders. In our view, the solidarity measures are not sufficient. As you heard in your first session, the rules on responsibility sharing that appear in Dublin remain largely the same. And the default option is country of first arrival. Although, according to the current Dublin rules and the future Pact rules, if they're accepted, family reunification should be higher priority than the default option of where people arrive. In practice, this is not applied by many member states, with a frequent turning down of take charge requests based on the family reunification criterion, including by the Netherlands. So we don't imagine that things will work differently despite some small positive changes. There are also negative changes at every point, including on family definitions. There are 2 solidarity mechanisms proposed for search and rescue and for migratory pressure. And in a sense, we welcome them, but our suggestion would be to reform the basic rules instead of keeping unfair and dysfunctional rules on responsibility and then adding corrective mechanisms, which themselves are highly complex legal constructions. So you add complex legal constructions onto dysfunctioning rules. It's very bad law, ultimately. The solidarity mechanisms are initially voluntary and then become compulsory. But there are options for the member states: relocation, return sponsorship, and capacity building in certain circumstances. Our concern here is that it may make it politically impossible for countries to choose relocation, which is the solidarity option that is desperately needed. Return is a theme throughout the proposals, and this is based on a rather simplistic analysis that increasing returns will solve all problems in Europe. It really won't. Most people arriving do have protection needs. And this is often overlooked because there's a focus on first instance decision making, whereas if processes are followed through to the end, we see that the majority of those arriving have protection needs, and as Unhcr have explained, forcible displacement is at record levels. The border monitoring mechanism was discussed in your last session. We agree it could be a positive positive element, but it has to be independent, it has to monitor borders, and it has to be a mechanism. There is a risk that it is none of these things, and I would like to draw your attention to the situation currently in Croatia, where the Commission may approve a mechanism that is essentially a whitewash managed by the ministry that is supposed to be being monitored. The screening proposal also proposes a very limited mechanism that doesn't look at all the things happening at the border. The second second question, the role of the Netherlands. Reflecting on the role of the Netherlands in EU policymaking on this issue in recent years, we would draw a distinction between the role of Dutch MEPs in the European Parliament and the role of the Dutch government in the Council of the EU. Dutch MEPs across political groups have played a key and important role, largely informed, defending fundamental rights, promoting effective and pragmatic and European solutions. In the Council, unfortunately, the Netherlands has often been focused on the objective of preventing secondary movement, regardless of the impact, rather than on making asylum work. At times, its approach is conflictual, leading to tension rather than compromise with other member states. And we've seen it be both patronising and antagonistic towards other member states. This makes improvements in those member states and a European solution more difficult. So we would suggest from the Parliament and with the new government coming in, many of the parties that I refer to in a positive sense as having MEPs active on this issue, doing important things at the European Parliament, will be in the government. So we would hope to see a broader approach from the government towards the Pact, looking at all objectives, and a focus on compliance with law that exists in asylum, but also related areas such as the law of the sea, which ultimately is a Dutch invention, if we may say, and is undermined by some of what's happening within Europe. We would also suggest a greater effort to understand other perspectives, including the perceived unfairness that the current system poses for certain member states. And here I would refer to some of the points in another piece of advice from the Adviesraad Internationale Vraagstukken, where we wouldn't agree with all recommendations, but some of those on understanding the ideological differences of other member states, I think are important. Finally, let me conclude with the third point: what can be preserved? If we look at the Pact...
I'm sorry, Ms. Woolard. Can you complete your speech, please? Thank you.
Certainly. Let me conclude then with our suggestions for what can be preserved. For the Pact, I would summarise this as safeguards, alternatives, and status quo. Safeguards throughout. We've produced detailed article-by-article analysis of the legislative proposals, so you have more information there. We would also suggest looking at alternatives, such as an alternative crisis mechanism that is based on giving protection to those who have manifestly founded cases and operational crisis response, removing elements such as a force majeure legal regime, which allows derogation in situations of supposed crisis, the last thing we need now is allowing derogations when there is flagrant non-compliance with EU law. And finally, I would suggest in this process of negotiating the Pact, not neglecting the fact that we have extensive, complex asylum law already. And one of the key issues is looking at the implementation gaps that exist and making sure that there isn't this suggestion that things are currently happening in a vacuum, which is not the case, and one of the reasons why we see flagrant human rights violations and violations of asylum law at the borders, for instance. Thank you.
Thank you, Ms. Woolard. Would like to ask a question to Ms. Woolard. They are all speechless because of your speech, Ms. Woolard. I think it was rather clear. Okay. Okay, I thank you again for your speech. It was a clear speech, no questions. Then I can go to the next speaker, and that's Mr. Mouzarakis, legal officer at the Refugee Support Aegean. Please take the floor, Mr. Mouzarakis. Sorry.
Thank you very much, Chair. Good afternoon, honourable members. Thank you very much again for the kind invitation to today's discussion. Catherine's intervention was absolutely clear and on point on the elements that have also occupied us when it comes to our assessment of the new Pact on Migration and Asylum. So in an attempt to be as brief as possible, I would quickly go through three key issues identified and 3 points of potential focus for the Dutch position going forward. As previous speakers have also said, the border procedure undergoes a multi-dimensional expansion in the Pact. So that means that more people will go through border procedures for longer periods and potentially in more physical spaces. The fiction of non-entry, of course, in our reading means deprivation of liberty, whether formally or de facto. So that raises crucial fundamental rights issues, but also feasibility issues. Can we actually implement such a policy at all external borders of the Union? More specifically, when it comes to screening, which is largely modeled on the existing reception and identification procedure, as it's called, applied on Greek points of arrival, mainly the islands, but also the Evros-land border. We also raise questions as regards the added value of the proposal. This particular proposal largely legislates on aspects that actually exist already in EU law, be it registration, vulnerability assessment, referral to appropriate procedures. So the risk of creating an additional layer of procedure that would be governed by domestic law instead of EU law, with potentially high risks for fundamental rights, even though more legislation is not necessarily the answer, when implementation problems persist, is a huge question mark for us. And the onus would still be on the Commission to explain why we need more laws, even though the existing and enforced provisions are not being applied. Second issue relates to solidarity and relocation, which has been also amply discussed, of course. What gives us pause from a Greek perspective is the fragmentation of it all. Even within the rubric of relocation, we have a bric-a-brac of ad hoc schemes that seems to codify the existing approach, where we have one scheme for search and rescue, such as the one applied from Italy and Malta, a different scheme regardless of mode of arrival for vulnerable people, which is one of the many schemes currently applied in Greece, and different possibilities to relocate beneficiaries of international protection, also happening in Greece following the Moria fires of September. One of the very difficult lessons that we're encountering from the Greek context at the moment is that there is, of course, very much welcome political impetus and action to share responsibility and to do relocation from Greece, but there is a persisting underlying lack of clarity and consistency on the system itself. In one country, we have at least 4 different relocation schemes implemented voluntarily by different member states, subject to different criteria, different procedures. It's impossible to have a uniform picture on how the process is happening. Third issue relates to crisis, the crisis and force majeure proposal that was put forward by the Commission. I would very much echo Catherine's point on this contributing to an ill-fitting crisis framework, crisis rhetoric in terms of managing migration, contrary to the Commission's overall objective of normalizing this policy area. And I would also highlight that the SEAS in force provides quite a few possibilities for member states to gain flexibility when encountering large numbers of arrivals. This has also been acknowledged by the Commission itself before the Court of Justice of the EU in litigation. The risk of misuse by member states is quite palpable, and I think we have various examples to back that up, ranging from the extreme case of Hungary legislating on mass migration derogation regimes consistently, even with 0 arrivals, even to the Greek example of a country that has implemented a fast-track border procedure by way of derogation on mass influx grounds, uninterrupted through the full implementation of the EU-Turkey deal. Whether we had high numbers of arrivals or, as in 2020, very sharp drops in arrivals. The fast-track procedure stays intact. So in our view, this is quite detached from the notion of crisis and large arrivals. 3 quick points on areas where we would deem useful, let's say, for the Dutch position to move into, specifically when it comes to negotiations in the Council as these are progressing. One aspect also previously touched upon relates to the often unequivocal insistence on pushing border procedures. This is something that the Dutch government has very much advocated for in the Council, where different member states have, of course, very different positions. One thing that for us is quite crucial is that the border procedure applied in Schiphol Airport is fundamentally different from the one rolled out on the Greek islands. There are very important distinctions that would need to be taken into consideration, not only in terms of numbers. Illustratively, according to available statistics in 2019, the number of people that went through the border procedure in the Netherlands was 920. In the Greek border procedure for the same year, it was 42,000. That's more than 40 times higher a caseload that has to be dealt under very truncated deadlines in very confined points at the external border. The second issue that is often largely overlooked is the scope of processing. EU law is quite clear that the border procedure should not look at the full merits of a case. It should look at questions such as admissibility or manifest unfoundedness. That's also the approach that is followed by Dutch legislation and practice. In contrast, despite clear legal standards at EU level and even in Greek legislation, the fast-track border procedure in Greece, since the very beginning of its implementation in 2016, actually does full processing for the majority of cases. So we have claims that are processed either on admissibility or on admissibility and full merits. That means more time, more complex assessment in a procedure that is not equipped for that purpose. A second area where we think it would be useful for positions to evolve would be...
I'm sorry, Mr. Mouzarakis. Can you complete your speech, please?
Absolutely, yep. Thank you. So a second element would relate to demanding clarity and better lawmaking from the side of the Commission as a co-legislator. For us, the Netherlands has been one of the member states that not only has been key and a key ally in the coalition of willing member states to have a different approach in terms of the SEAS, but also one of the countries that has actually pushed the development of SEAS standards, not only politically through legislation, but also through judicial interaction. The number of references to the Court of Justice of the EU from Dutch judges that has made sure that EU law is clear and protective is quite telling of the role that the Netherlands has to play. So in that sense, we would urge for resisting the regression of standards that comes with many of the proposals, specifically the APR, but also the AMMR, and with focusing on implementation of some of the very positive but very much theoretical provisions of the existing acquis. Thank you very much.
Thank you, Mr. Mazarakis, for your introduction. Who would like to ask a question to Mr. Mazarakis? Ms. Vos, please, take the floor.
Well, it's just your last point. I didn't understand it quite clear. I guess I didn't. Could you please repeat what you said and what you meant with the Dutch procedures and SEAS? Because I just couldn't grasp it.
Yes, apologies. So the point relates to several provisions in the Commission proposals of the EU Pact that attempt a regression of existing standards. Examples include the right to appeal in Dublin decisions, where despite clear positions from the Court of Justice that have been the result of Dutch preliminary references, the Commission attempts to restrict the scope of appeal. Other examples relate to suspensive effect of appeals in the APR, where, contrary to the Commission's own admission in the preamble that suspensive effect would only be excluded in cases that are presumed to be unfounded, this is actually expanded to a wide number of cases, including implicit withdrawal, where the authority has actually never looked into the merits of the case. So these would be a couple of examples where very protective standards, not only in terms of refugee protection, but also the rule of law, are being tampered with the aim of facilitating deportation.
And you would like the Dutch government to oppose to that?
Indeed, yes.
Thank you. Ms. Karimi, please take the floor.
Yeah, thank you very much. I would like to ask actually a question to Ms. Woolard and Mr. Mazarakis, both of you. As you know, the German presidency tried actually to achieve a kind of political agreement amongst the member states on this pact, which was presented actually in September, and that was not possible. Now, Portuguese presidency is trying to do the same. Until now, also not really a big progress on that. So my question is, you are both from, I guess, European organizations, so you have also activities in different member states. What is your appreciation of the situation? What do you think? What do you hear from also other member states? How how do you think that this is going to actually achieve a kind of result? Could you share some information that you have with us? Maybe Ms. Woolard wants to go first.
Yeah. Yes, thank you. This gets to the heart of the politics of the situation. And I think what we've seen is that the deal that underlies the pact currently is not enough for particularly the countries at the external borders. And I would refer just to the recent Mediterranean 5 group of states that met and expressed a very strong opinion rejecting many elements of the pact. And we assume that Portugal is also part of that grouping. Currently, they hold the presidency, as you've mentioned, Ms. Karimi, so have to be more neutral. But that gives us at least 6 countries that are strongly opposed to the elements in it. And I think that their calculation is that they're not being offered enough solidarity that would compensate for an increased responsibility and the political tension that will be created in their own countries through having to manage detention centres and border procedures and so on. And the solidarity piece is not sufficient because the Dublin rules themselves largely remain unchanged, and there's even increased responsibility in some cases. And the solidarity mechanisms don't adequately compensate, and they don't involve always relocation. So it may be that the political conflicts that we saw after the 2016 reform proposals came out have not been resolved. So is there another deadlock planned? Likely. Well, I would say what's slightly different this time is that the conflict between East and West, if we put it like that, the blocking minority of the Visegrad 4 countries is a bit less relevant, because there's a sense that they've just given up on trying to get any kind of solution with those countries. And in the end, there'll be an attempt to get some sort of qualified majority. And this involves then making sure that the countries at the borders agree to this. That piece, from our analysis, our members in Italy, for instance, it's very hard to see a way out of this that will be acceptable to those countries. If there is a deal offered, it would probably go beyond the asylum and migration domain and be offering something else. This is one of the reasons why the German presidency was unable to reach a political agreement, as you've mentioned. And I think in that context, I'll wrap up with this point. In that context, there are two risks to avoid. One is the sense that currently there is nothing. No, there is a detailed, complex legal framework, and no member state should be excused from implementing it. Secondly, in the absence of agreement among the member states, the option is to look outside Europe. And this is highly damaging both for global protection and also for Europe's foreign policy, because foreign policy becomes co-opted and used as a way to try to prevent people moving or to bribe countries to accept readmissions of people who get to Europe, rather than foreign policy being used to prevent forced displacement in the first place. And I would say the Netherlands is so strong on development, on modern, effective approaches to security, all the causes of forced displacement, that one of element of your position could be to defend those policy areas so that they're not used to then actually be counterproductive and put in place measures that may lead to more displacement. And I would refer to the research of the Klingendahl Institute on this, which is really looking at the impact of internal affairs objectives seeping into external policy.
Thank you, Ms. Woolard, and also thank you, Mr. Mouzarakis. Is there another?
Could I perhaps make a short addition to this? We're based in Athens and mostly working on the Greek asylum system. So beyond the Greek perspective, we would probably not be extremely helpful. What I would perhaps highlight is that, of course, Greece is a very relevant and sort of topical member state for these discussions, and the extent to which this has created national tension, especially with the island communities, cannot be understated. So the whole discussion on border procedures is something where the central government is already facing very high levels of resistance, given the past 5 years as an experience for the islands. So we would also, bearing in mind the sort of united Mediterranean position in that regard, as expressed in the Med5, but also the 2020 joint statement at the heads of state level, which also conveyed a very important political message, that the disagreements that led to the deadlock surrounding the 2016 proposals have not really been overcome. One aspect that might be interesting to consider is how implementation and how current practice can not only avoid the risks that we perceive the current situation in a vacuum, but also drive healthier discussions in the Council to avoid the toxicity and avoid the deadlock. And there we see relocation as a very good example. Beyond and in spite of the very sort of strong disagreement between the member states, there is still a relocation scheme being carried out from Greece where a significant number of member states are involved in the game. And there, I think support for a more effective participation in relocation that would be meaningful also to the member state that requests assistance could be one way to provide momentum again and to bring member states around the table under different rules, let's say, to continue the discussion.
Thank you, Mr. Mouzarakis. Is there someone else who has still a question? No? Thank you. Then the last speaker of today is Mr. Nicolosi. He is the Assistant Professor in European and International Law at Utrecht University. Please, Mr. Nicolosi, please take the floor.
Thank you very much, Chair, for the invitation. I am very pleased to be here today, this afternoon, to present my point of view on the proposals underpinned by the new Pact on migration and asylum. My short presentation is based on the research that I conduct at the Utrecht Center for Regulation and Enforcement in Europe, where I also coordinate the building block on citizenship and migration. So in an attempt to provide with an assessment of the proposals underpinning the new Pact, I would like to reflect on the main issues in the legal framework and also reflect on the enforcement dynamics in the new Pact proposal. As I will be explaining, the Pact reflects a legal framework that does not fix the existing divergences between the member states. It presents incompatibilities with international law obligations, while at the level of enforcement, the legal design seems very precarious from the perspective of the role of the EU agencies and the legal remedies for the migrants. Let me now move to the first point. As regards the legal framework, I would like to reflect, first of all, very shortly on the principle of solidarity, which is a big deal in the new Pact. With reference to solidarity, I would like to mention that Advocate General Sharpston very recently stressed that member states and their nationals in the EU integration project have obligations as well as benefits, duties and rights. This requires one to shoulder collective responsibilities and burdens to further the common good. The common good in our case is the common European asylum system, and this system should be beneficial to different actors, so the member states and asylum seekers. The new Pact seems to pursue a more pragmatic approach, offering different forms of mandatory solidarity. In particular, member states can choose, as has been highlighted, to relocate asylum seekers, to sponsor returns, to help another member states to repatriate irregular migrants, or to provide other types of support, including external cooperation for migration management. This model of solidarity, in my view, actually produces adverse effects because it discourages member states from prioritizing the relocation of asylum seekers. On the other hand, considering that only 40% of third country nationals are effectively returned in Europe, from Europe, little expectations are also raised by the new Pact on the role of this return sponsorship. Finally, it seems that these sort of flexible but mandatory solidarity schemes leave actually, instead of producing a consensus, they leave the situation to a sort of permanent negotiation between the member states that can, of course, result in risks for the asylum seekers. What is particularly controversial in the proposal for the asylum and migration management regulation is also that it is not very cost effective and it is not even practical compared to the situation we have now, because according to the proposal under Article 58, for instance, if an asylum seeker is relocated, for instance, from Italy to the Netherlands, still there is a procedure to determine the responsible state that the Netherlands has to apply. This means that from the Netherlands, that asylum seeker can be returned to another member state of the European Union. As a result, the procedure is even more complicated, and before landing in a place where the asylum seekers can have the application assessed, in fact, an asylum seeker can undertake even 2 transfers. This is a situation that is not tenable, in my view, also from the human perspective. The second point that I would like to raise as to the legal framework is the role of the border procedures, and in particular the system that has been designed, including the pre-screening procedure. I see there a problem of incompatibility with international law, in a sense that the screening procedure would apply to 3 categories of migrants. These migrants are those who entered in an unauthorized manner, but also asylum seekers who entered without authorization and persons disembarked after search and rescue operations. I see that it's problematic, in particular, the fact that, according to the proposal, even asylum seekers are not considered as authorized to enter the territory of the member states. And this is a flagrant disconnection from what the Refugee Convention, for instance, predicates as the possibility to accept that asylum seekers or in general refugees can have access to the territory even if if they come without any prior authorization. The Refugee Convention also enshrines a number of rights for people that are in the territory, so within the jurisdiction of a state. For instance, the right to receive identity papers, the freedom from penalization for illegal entry, and to be subject also to limits to the free movement that have to be duly justified. I don't see in the proposals adequate guarantees for all these rights that stem from the Refugee Convention. What is more, if I move to the border procedure, I see another point of concern. And this point of concern regards the fact that the border procedure, in particular, should apply in cases that can be considered inadmissible, and cases that are to be considered inadmissible are cases of applicants that come from alleged safe countries. Now, the problem is how to define the concept of safe country. I see that the existing proposal, in fact, departs from the former legal framework, in a sense that in order to define safe a third country, the amended proposal for an asylum procedure regulation refers to the fact that applicants receive protection in accordance with substantive standards of the Refugee Convention or even sufficient protection. This new wording replaces the obligation to ensure that an applicant is transferred to a third country that is fully in compliance with the Refugee Convention. There I see the risk that, in fact, member states can abuse the use of the notion of safe country, even more than how it is happening nowadays. And it can be actually possible that applicants are transferred to countries that do not offer the necessary guarantees that an asylum procedure is in place in line with the Refugee Convention. Also, I would like to mention that at the level of enforcement, what happens at the borders should be supported by the role of the new agencies, in particular Frontex and the Asylum Agency, at the moment the European Asylum Support Office. I see that the proposals do not render justice to what these agencies are doing in practice. I see a disconnection between the de facto expansion of the mandate of these agencies with, for instance, the European Asylum Support Office that in Greek hotspot has been involved in interviews with asylum seekers or in vulnerability assessment. Without having the statutory competence, because the regulation at the moment does not give this competence to the European Asylum Support Office. So I expected that the proposal could render justice to what is happening, in fact, in these procedures at the borders of the European Union. But in fact, if we read the explanatory memorandum of the proposal for the European Union Asylum Agency, still the words are emphasizing the role of support and assistance that this agency has to play, without clearly embedding the executive mandate that this agency is already playing de facto in procedures at the border. Also, what is particularly concerning is the fact that when it comes to Frontex, Frontex has already a sort of more sophisticated fundamental rights mechanism. But the problem here is that this framework in particular does not seem to apply to those applicants that are, for instance, subject to intra-European Union transfer. To give you an example, a migrant that is under a return obligation in the territory, for instance, of Greece, and the return is sponsored, for instance, by the Czech Republic or by the Netherlands under bilateral cooperation, cannot take the advantage of the Frontex complaints mechanism because, according to the current proposals, this situation is not covered in the existing legal, in the existing proposals. Also, when it comes to the agency, I would like to make a point about the need to ensure that the fundings are also taken into account.
I'm sorry, Mr. Nicolosi, can you complete your introduction, please?
Yes, my last point, in fact, is that even the allocation of funds is important when it comes to the role of the implementation. So it is important, for instance, that the Asylum, Migration and Integration Fund consider not only the GDP or the number of applications, but also the material resources that countries have, because the resources of Greece are different than the resources of the Netherlands. Finally, at the institutional level, I would like to stress that there are member states, in particular from the south, to Italy and Spain, that are asking for a package approach. I would like to suggest that the package approach, in my view, is not a way to speed up definitely the procedure and the negotiations, because the current proposals are extremely sophisticated, and addressing these proposals as a package risks actually to delay any sort of compromise on the new proposals, and also delaying the possibility to adopt other proposals, such as the qualification regulation, for which a compromise was already reached. And perhaps it's also important that at the European Council level, these proposals are discussed, because I didn't see that much involvement of the European Council as it happened in the past with the multi-annual framework. I see that this pact reflects the ambition of the European Commission, but I think that sooner or later the member states at the European Council's level should address what kind of consensus it is feasible. Without these 2 points, institutional points, I think that this pact would remain a dead letter as the former proposals from 2016. Thank you very much.
Thank you, Mr. Nicolosi. Does the committee have any questions for Mr. Nicolosi? I see Ms. Tine has a question. Please take the floor, Ms. Tine.
Yes, thank you, Mr. Nicolosi. I'm trying to digest what you and the other speakers have been saying, and it doesn't make me very optimistic that this new EU migration pact will actually bring any solutions. And what you said about that we might enter a permanent discussion without really giving justice to the people involved is a very pessimistic thought. Maybe you said it in between the lines, but I'm also curious to know your assessment of what the opportunities are for legal migration in 2021 and an EU level. And then to what extent this EU Asylum and Migration Pact can be helpful or detrimental to developing some kind of a blue card or legal ways for people to migrate to the European Union?
Yes, thank you. Thank you very much, Mrs. Steen. And indeed, legal migration is also a point that is addressed in the Pact, although in a way less direct compared to the proposals in the field of asylum. What I can say about legal migration is that there is a reference to the reform of the Blue Card Directive in a way to for instance, lower the salary threshold and to increase intra-EU mobility possibilities. But this is a proposal that, although can be welcome, has been opposed by certain member states, and I'm afraid that the Netherlands was one of those member states that were against these major changes to the EU, to the Blue Card Directive, in particular concerning, for instance, the lifting up of the restriction concerning the national clause, so the possibility to prioritize first the EU workers compared to third country nationals. So I think that there are good points, but the political feasibility, in my view, at the moment raises more doubts than certainties on how this reform can proceed. Another point concerning legal migration is how to make a good advantage of the directive on the long-term residence, because at the moment, although this is a directive that can ensure free movement to third country nationals after 5 years, the objective is in particular to create a sort of better framework that allows free movement after 3 years. But in this area also it is in particular evident the divergent approach of member states, because I don't see a sort of consensus in reducing the 5-year period before this directive can result applicable to third country nationals. There are also other points that are interesting and that can, to a certain extent, link to the practice of other states in the international community, such as Australia or Canada, in particular, the way to create this EU talent pool for skilled worker. But the EU framework, because of course it's a framework that includes 27 different national frameworks, is particularly difficult to realize. So in practice there are also administrative issues that have to be addressed before a genuine model of legal migration in that regard can be materialized, in my view.
Thank you, Mr. Nicolosi. Someone else has a question. Yes, please, Ms. Kuhnen, take the floor.
Yes, I have a question for all three speakers. My name is Jan Keunen. Many thanks for your comments. Do you have for the members of the Dutch Senate a take-home message? What is important for us to take home today? And can you give each a statement on this? Is it possible?
Okay, who wants first? Yes?
Ms. Woolard.
Please, Ms. Woolard.
Yes, thank you. Sorry, there was a trouble unmuting my microphone. So let me answer. I think a key message is that there are alternatives. We and other experts you've heard from have been critical of the Pact, and that's because we don't see it as resolving some of the current challenges. That doesn't mean these challenges can't be resolved. There are multiple ways forward, and the message that should absolutely not be taken is that asylum in Europe is impossible. No. We would suggest another deal, a deal based on solidarity in exchange for compliance with existing standards, compliance with international law, and offering solidarity only when some of those serious compliance issues are dealt with. Safe and legal pathways has been mentioned by many. Massive expansion of asylum and non-asylum legal channels. Part of that could be through the EU, but it doesn't necessarily have to be bringing that into EU law. Which country currently offers most legal migration places for non-asylum migration? Poland. Putting this into the EU legal order is not necessarily going to increase numbers, but there's still multiple things the EU can do. So, for instance, looking at questions of exploitation of undocumented and other third country nationals, which is actually much more of a pull factor than many of those that we hear spoken about. And then inclusion, integration through rights, respect, regularization in some cases, but rights to employment, housing, and stable status, mutual recognition of asylum decisions, more legal opportunities to move once people have status. There are many things, in addition, looking at the root causes, the prevention of forcible displacement, rather than co-opting foreign policy. As I mentioned before, I think those are areas where the Netherlands has really interesting, solid experience and evidence.
Thank you, Ms. Woolard. Mr. Mouzarakis, do you want to add some of your views?
Thank you very much. Along similar lines, I would agree that the new Pact on Migration and Asylum is not the answer to our discussion. So in our view, it's not the basis for a way forward. 3 key takeaways would be, first, to implement the existing rules, because there are rules. And I would add to push the Commission to have more tools and more political power to do enforcement, not only in the extreme cases of, let's say, a Hungary-type situation, but across all member states, because problems arise in most member states. The second one would be to give tangible and meaningful support for solidarity through relocation, to ask, to assess the needs in the countries that require and request relocation, and to respond to those. And finally, going forward in political debate, to decouple asylum and refugee protection from the border. This is a connection that I think is at the heart of many problems and that deadlock. Thank you.
Thank you, Mr. Mouzarakis. Mr. Nicolosi, do you want to add some of your views?
Just 3 messages, Madam Chair. So, first of all, avoid confinement at the borders, because this can create a situation like the one in Moria, and we see how the impact, how bad the impact is on the health of asylum seekers. Second, make sure that the system is accessible. We need a system, a common European asylum system that is accessible. So let's change the approach. What we need is not necessary to prevent that any person arrives in Europe, and if a person arrives, we make sure that he or she remains trapped at the borders. We have to make sure that people that arrive in Europe can have a clear and safe itinerary to integration. Finally, if we have to negotiate this pact, let's make sure that the negotiation can produce some fruit. So let's move from this package approach, because there are proposals that still need to be adopted. And one proposal can be already adopted, for instance, the qualification regulation, and can be already implemented while keeping the existing rules that can be indeed implemented, as the other speakers stressed before. So That's the threefold message that I want to conclude.
Thank you, Mr. Nicolosi. Then I would like to close the meeting now. I want to thank the experts who have shared their views with us and the senators for asking their questions. Thank you so much for taking part in this video conference. Thank you.